Welcome back. When a business hits hard times, I think the first instinct for many owners is, well, call the bankruptcy court, right? Sort of hit the reset button legally.
That's the calming thought, absolutely. But today we're digging into a viewpoint based on Peter Francis Geraci's principles. That's pretty counterintuitive.
Right, the idea that maybe, just maybe, for small businesses, bankruptcy court is actually the wrong move, especially at the wrong time.
Exactly. We're not focused on, miraculous turnarounds. It's more about efficiency. How do you minimize the damage, financial and personal, when things are genuinely failing?
And the core idea from the sources seems to be that bankruptcy law is really designed to help people get a fresh start.
Yes, precisely. Not necessarily to prop up a business model that isn't working anymore.
So it's all about timing, it seems. Getting that wrong could make a bad situation even worse. The key question for you listening is, when do you stop pouring energy into saving the company and start, well, saving yourself?
It really requires some clear-eyed realism. Like Geraci Law points out, if the core business model is broken, losing money consistently, the legal system itself can't magically fix that.
It just helps clean up afterwards.
Right, after the fact.
Okay, let's start with the most common route people think of. Chapter 7, liquidation. The idea is you file, close up shop, and the company's debts are wiped clean. But you're saying there's a catch.
There is, and it's a big one. This is probably the most costly misunderstanding for small business owners. The business entity itself, and the LLC, or the corporation, it doesn't actually get a discharge of its debts under Chapter 7.
Wait, hang on. The company files bankruptcy, it goes through the whole process, pays the lawyers, the court fees, and it doesn't get debt relief.
Correct. What happens is the court appoints a trustee.
Okay.
And that trustee's job is to sell off any remaining assets, equipment, inventory, whatever's left, and then distribute whatever cash they get to the creditors according to priority.
And then the company.
The company effectively ceases to exist. It's liquidated. But its debts aren't forgiven in the way personal debts are in bankruptcy. They just remain unpaid because the entity that owed them is gone.
So you could spend thousands on legal fees just to end up closing down, which you could have done anyway.
Exactly. If liquidation is the inevitable outcome, the advice is often to handle it yourself. Pay your crucial taxes, sell off what you can, close the doors properly. You achieve the same result without shelling out thousands in court and legal fees.
You save that money, which you probably desperately need at that point.
Precisely. For a business entity just looking to close, Chapter 7 is frequently just wasted money.
All right, so if Chapter 7 for the business itself isn't the magic bullet for liquidation, what about trying to save the business? Chapter 11, reorganization.
Ah, yes, Chapter 11. It's tempting, isn't it? You read about airlines or big retailers using it to restructure billions and come back leaner.
Yeah, it makes it seem like a viable path for, the local restaurant or the small shop down the street.
But the reality, according to the sources we're looking at, is, well, it's pretty brutal for small players.
How brutal?
There's a really sobering statistic. Something like 95% of businesses with under $2 million in sales that file for Chapter 11, they fail to successfully reorganize.
95%.
95%.
Yeah.
They usually end up liquidating anyway.
But only after spending a fortune trying not to.
Exactly. Only after burning through tens, maybe hundreds of thousands of dollars in legal fees, accounting fees, court costs, and valuable time.
Why such a massive failure rate compared to the big corporations? Is it just the cost?
Cost is a huge part of it, yes. Chapter 11 is incredibly complex and expensive. For a giant company, those fees are, a fraction of their overall operation. For a small business, those fees can be their entire remaining cash reserve.
So they spend their last dollars essentially arguing in court.
Pretty much. Arguing to save a business model that fundamentally wasn't working. Remember, bankruptcy can't fix declining sales or bad margins.
Right. It's a legal process, not a business consultancy.
Exactly. It forces you to spend critical resources trying to convince a judge that this flawed model will suddenly turn profitable. Usually, it just delays the inevitable and drains the owner's personal savings in the process.
So the advice again is, if the model's broken, stop the bleeding first.
Stop the bleeding. Don't throw good money after bad in the court system.
Okay, let's shift to the legal structure itself. Corporations, LLCs, lots of owners set these up specifically for liability protection. They assume if the company is incorporated, the company has to file bankruptcy, right, to protect the owners.
That assumption makes sense, but it depends entirely on whether the owner kept things clean legally. If it's an LLC or a corporation, and this is the key part, The owner did not personally guarantee the debts.
Like the lease or a big bank loan.
Right. If there are no personal guarantees, then generally only the company is on the hook. In that scenario, the best move is often just to close the company down, dissolve it according to state rules.
No business bankruptcy needed at all.
Correct. Saves a ton of time, money, and hassle. Just wind it down properly.
That must be a relief for owners who are careful about not signing personally. But I sense there's a but coming. There's always a catch, isn't there?
There is a huge one, a massive exception that pierces right through that corporate shield.
And that is?
Trust fund taxes. This is the debt you absolutely cannot walk away from just by closing the business.
Okay, explain trust fund taxes. What makes them different from, say, unpaid rent or a supplier bill?
Think of it like this. The business was collecting money on behalf of the government. It was holding that money in trust. The classic examples are employee withholding taxes, income tax, Social Security, Medicare deducted from paychecks, and sales taxes collected from customers.
Ah, so that money never really belonged to the business in the first place.
Exactly. It was collected specifically to be passed on to the IRS or the state tax authority. Failing to hand it over isn't just a business debt. The government views it as the responsible individual's owners, officers personally failing their duty.
So even if you have an LLC or a corporation, you personally can be held liable for those unpaid taxes.
Absolutely. The IRS and state agencies will pursue the individuals. These debts are generally not dischargeable in bankruptcy, either business or personal, and they have long statutes of limitations. They can follow you for years.
Wow. So if the business is still operating, even barely, the absolute priority should be paying those trust fund taxes.
Get current and stay current on those specific taxes. Filing business bankruptcy won't protect you from that personal liability anyway. It's critical.
Yeah, okay, that's crucial. Now let's flip to the other side, the sole proprietor. The person is the business. No corporate shield at all.
Right. For a sole proprietor, every business debt, the lease, the supplier counts, the loans, is automatically a personal debt from day one. The liability is total.
So in that situation, if creditors are breathing down their neck, wouldn't it make sense for them to file personal bankruptcy immediately to stop the bleeding and maybe even save the business?
It seems logical, but again, it comes back to timing and what bankruptcy actually does. Bankruptcy discharges existing debts at the time of filing. If the business operation itself is still losing money, filing bankruptcy today gets rid of yesterday's debts. But what about the losses you're going to incur next week and the week after?
Ah, you'll just rack up new debt immediately after the bankruptcy.
Precisely.
Yeah.
You end up right back where you started, potentially unable to file again for years.
Huh.
So the core advice, even for a sole proprietor, remains. If the operation isn't profitable, stop. Shut it down first. Cut the losses.
Stop digging the hole deeper.
Stop digging. Then, once the business is closed, and crucially, once the individual has found other employment and has stable income again, that's the time to consider personal bankruptcy.
Why wait until they have a new job?
Because then you're dealing with a fixed amount of old debt from the closed business. You're not creating new business debt. And having stable income makes the bankruptcy process smoother. It shows the court you have a path forward.
So you close the business, get back on your feet with a regular job, then use personal bankruptcy to wipe out the leftover business debts, which were personal debts anyway.
That's the strategy. You use the bankruptcy tool when it can provide a truly fresh start, clearing away the wreckage of the past venture.
Let's make this real. Tell us about Jose and his hot dog stand.
Yeah, Jose's a good example from the material. He ran a hot dog stand, simple sole proprietorship. Things went south, maybe rent went up, foot traffic changed. He fell behind.
Like many owners, he probably tried to save everything.
He did. Borrowed money, used personal credit cards to keep it afloat. But eventually the business failed, and he got evicted. The stand was gone.
So now Jose's out of business. What's his situation?
He did the smart thing. He got a job as a cook in a restaurant, earning a steady $32,000 a year, enough to live on. But the creditors from the hot dog stand, the cart loan, the credit cards he used for supplies, they're still coming after him personally. Lawsuits, collection calls.
Because he was a sole proprietor, those debts follow him.
Exactly. They're legally his debts,
Yeah.
but now is the perfect time for him.
To file personal bankruptcy.
Yes. Personal Chapter 7. The business is gone. No new business debt is being created. He has stable income. He files, lists all those old business debts, along with any other personal debts he might have.
And gets a discharge.
Within a few months, typically.
Right.
He gets that discharge. The lawsuits stop. The calls stop. He gets that genuine fresh start the law intends.
If he had filed while still trying to run the failing hot dog stand.
It would have been pointless.
Yeah.
He'd discharge some debt, run up more debt, and still be stuck. The timing after closure and reemployment was everything.
It really highlights the emotional trap, doesn't it? Wanting to save the business at all costs can actually prevent you from using the legal tools available to save yourself.
That really sums it up. Bankruptcy isn't there to magically resuscitate a failing enterprise. It's there to help people, individuals, recover after a venture has ended. It takes courage to run a business, absolutely. But it also takes a different kind of courage, clear-eyed realism, to know when to stop.
And there's no shame in that closure. The real mistake, the sources argue, is dragging it out so long that it destroys you personally, taking down your savings, your home, your future.
Exactly. If the business is truly finished, let it be finished. Focus on rebuilding your personal financial life. That's when bankruptcy can be incredibly helpful.
A clean slate when you actually need it to move forward.
So the final thought for you listening is this. If you're in that tough spot where the numbers just aren't working month after month, what's the hard truth you might be avoiding about the business itself? And forgetting bankruptcy court for a moment, what practical steps could you take right now to start winding things down responsibly, protecting yourself personally before things get legally complicated?
That strategic closure, that realistic assessment, that might be the most powerful first step toward whatever comes next.